So, hello everyone. Good evening
Hello.
to all those joining from India. Good morning if everyone joined from USA. My name is Madhura, and I welcome you to today's ILA event, which is in a form of an open discussion forum. So, today we'll be discussing a few important issues which would be a part of a letter which we intend to send to India's Honorable Law Minister in terms of the suggestions for how to make our legal system countries one of the best in the world. So a bit about ILA. So Indian Lawyers Association is a wonderful national level platform working, mentoring, guidance, sharing platform for all the legal professionals in the country. And because we happen to have a very huge vision, a very broad, deep vision, we operate in the form of having chapters, local chapters in all big cities of the country. So currently we have about 75 chapters, and all these chapters add local flavor to how our ILA operates in their city. So apart from hosting usual events, webinars, trainings, workshops, or even in-person activities like donation camps, celebrating festivals, here are some of our newest initiatives. So we have chapters in Rajasthan which happen to be very enthusiastic in terms of offering different trainings. So we have recently started a series under drafting and pleading, which is hosted by the chapters in Rajasthan. Then we also have recently launched different WhatsApp groups. So through these groups, we have started a movement where lawyers in all different cities come together on their own particular WhatsApp group. So there they network, they share about opportunities, they share their learnings, they share anything that they feel useful with the lawyers in their city. Then we have also come out with one unique thing where we are trying to share content in local language, especially Hindi or languages in southern part of India. So we have received this feedback that, don't just stick to English because not all lawyers or especially lawyers from smaller cities find it very relatable, connected. So they have suggested us to go with local languages, and we are working on that. One of our very new and interesting thing coming up is a placement and internship portal that's just under process. It will be live on our website soon. So through which, because we're already a very strong network of lawyers, we also want to offer this platform which helps people get jobs, refer, suggest internships, and so on. While we do one event per week, we're also trying to do live sessions more frequently, which will help people learn about what's happening today. So while we also talk about broad issues like this one today, we are also interested to talk about different and smaller topics under legal education. So it would work in terms of continued education format. So this is our upcoming event, which is happening on next Saturday. So this is a third session under drafting and pleading. And we'll also send a detailed email to all of you so you can join in for this. So with this, I hand it over to Mr. Navneet, who is the founder of Indian Lawyers Association and the managing partner of the Chugh Law Firm. Sir, over to you.
Thank you, Mathura. Thank you for doing a great job with the Indian Lawyers Association. Ever since we started in January 2018, we've been wanting to write this letter to the law minister. It's taken us 4 years to actually get to a session where we could talk to other lawyers and get their viewpoints on what should be included in the letter. Some of the obvious things are obviously the delays in the 49 million pending cases, and some of the lawyers are in prison that we can't advertise. We can't take matters on a contingency basis, and more plea bargaining in criminal matters so they get resolved quickly. So we'd like to hear from every one of you as to what do you think are the 51 most important things that the law minister could do, should do, that would create a system of good justice in the country. The world ranking of judicial efficiency and justice, India ranks very poorly So we need, if we want to be a first world nation, we can't have a third world nation legal system. So I request everyone to please give us their ideas that we can include in our letter. We start with you, Ms. Wahi.
Good evening, everybody. One of the things that this is the first time, by the way, I'm attending it, and I would love to be a continuation part of it, as I was discussing with Madhura. One of the things I feel is, the natural justice itself is a little lopsided. There is something known as, you are innocent till proven guilty, but unfortunately, it's just the other way around. And I think something needs to be done there. Another thing is, why are we taking so long? We talk about, there's too, is there really autonomy there? I'm not too sure. Too much of media coverage is happening at certain cases, which I'm not sure is really, helping both the parties, to be very honest. I mean, and this is what I very strongly feel about. And I was also mentioning that I was teaching in a law college at one given point of time before retiring. I think, our whole, the way lawyers are being trained is also not very hands-on. So most of them, for example, the syllabus changes after 10 odd years, everything is so, it's obsolete actually, to be very honest. So I think a lot of, so when we are talking about bringing in changes, we're talking about improving our legal system. I think we have to start from the very grassroots, which basically means from the student itself.
Okay. Do you have any, do you have experience dealing in criminal law, helping people with criminal matters?
Yes, I have, because as a counselor, yes, I have. And yes, that's why I very strongly feel that the whole system, I'm sorry to use the word, but stinks. They, for so much, especially for, your family courts. I mean, unnecessary delays, unnecessary everything. Why is something that I really don't understand.
What is the reason for the delay?
To be very honest, I think it's the lawyers. They see, I have cases even today, since I'm a counselor and so, I work with them. For example, they will just not arrive. They'll just not arrive. And, so I agree. We, as a counselor, we do try to patch up things. We do try our best. But once we've reached a, a situation where we know there is no, this, it's not going to help. So why not expedite the whole thing? Also, when it comes to children, I mean, especially the issue of a joint custody or, when the whole thing, I find most of the lawyers becoming the counselors and saying, they just stay in your marriage because of the sake of the children. Our studies have shown, the worldwide studies showing that the child growing up in a single, with a single parent, with a joint custody is much better off than with both the parents who are fighting 24/7. Doesn't make sense. It's such a unfair. So that's where I find, I mean, the roles are not well defined. They're overlapping and therefore a lot of delay. I'm also sorry to say, in one or two cases we've had that, my lawyer would be, in consensus with the opposite party's lawyer, and then things would go haywire.
Okay.
Yeah,
Thank
I know
you.
I'm sounding horribly horrible, but then that's the way I look at it, and that's the way my experience is.
So Jaideep Mehta, if you were made law minister for one day and you could only do one thing, what is that one thing you would do?
Sir, first of all, good evening to all of you. And I am also attending for the first time this meet and hope to attend all future meetings regularly. And
Yes.
the one thing which I would do is, which I have experienced since I am practicing in Bombay High Court and NCLTs mainly. So first thing which I would do is to fill up wherever the vacancies of judges are there. That needs to be filled up very quickly and rather immediately, I would say. And because there are lot many candidates are available, who are really very talented and intelligent and who are willing to join judiciary, but they are not given opportunities. So either the applications are pending with the ministry and they are not approved, and that is one of the reasons. So if you ask me as a law minister, the first thing which I would do is to fill up vacancies in the judiciary, starting from the lowest court up to the apex court.
Okay.
Do you have any idea on how many vacancies are not filled?
No, sir. Right now, I don't have any idea, but especially in various metropolitan magistrate courts and district courts, there are huge vacancies. The reason being, as everybody is aware, every 3 years judges are transferred to other districts, and that vacancy are not filled up immediately. So sometimes, for example, in one of the district court where I went, I'm going in Bombay. So almost for about a year or so, the court is vacant and the cases are piling up. Sometimes then what happens, the cases are transferred to other courts and the other courts are overburdened and they are not
Right.
able to cope up. And again, so that adversely affects the justice delivery system of the country. So exact number I'm not aware, but that can be, I mean, MIS, I can take it from the website is available, so I can gather that data and I can share with you, certainly.
What I recall reading once 5 years ago was that there's 70,000 requirement of judges in India and there's only 21,000
Bapre.
judges.
Oh.
So that speaks.
So Soham, you are law minister for one day. One thing you can do.
Namaste everyone. This is my first ever opportunity on this platform. If I were made law minister for one day, I would definitely try to reconcile the relationship that is right now under some stress with the judiciary. Because first and foremost thing is, if two pillars of our democracy, that is legislation and judiciary, does not work in consonance, there is going to be great disasters loading on their way. And another aspect is that because of this never-ending fights, which are very sublime, I would say, it actually affects the administration of justice and smooth working of judiciary. The most affected region would be the litigants. They have everything to lose. They keep on waiting for generations after another, and they don't get justice. That one basic thing that they always wanted to have was their violated rights soothed up. We cannot always give them back what they once had, but there has to be some sense of balance, some sense of working justice. So first and foremost thing that I would rather go with is reconciling and coming up with basic limitations and Lakshman Rekha regarding what not to do as a law minister, how not to comment upon working of the judiciary.
Yes.
But aren't they supposed to be two distinct branches of the government, that the legislators do what they do and make laws, and it's the judiciary that interprets them, and one shouldn't have a bearing on the other and they should be totally independent?
Right now, the situation looks more like two weak walls supporting each other and not falling because of each other. But the thing is, as you rightly pointed out, that the original idea was to make judiciary independent of all of the executive and legislative functions, was to the basic requirement, or rather the foresightedness of the makers of Constitution of India, was to avoid all the conflicts that we are looking at right now. For example, let me give you one brief example, that we are having this uh, great debates going on regarding marital rapes. Now, marital
Mhm.
rapes are nowhere recognized in the law, not punishable as of now, but not by making a legislation or not by enacting another law, the Supreme Court, or rather the judiciary, is being asked by the petitioners to introduce another species of uh, what you can say a punishable offense, just by
Mhm.
striking out that exception to the law, to the crime that is recognized as rape, but marriage is not falling within the nexus. So just by eliminating an exception, if judiciary is empowered to, and luckily not going for making or rather enacting a new species of law, if that would have happened, the floodgates are open and things are very lucid in that sense.
Mhm.
So it is about deciding their own limitations. If limits are decided by the office bearers themselves, it would be followed more likely to be in that scenario as compared to the other scenarios where they feel it as a limitation to their powers.
Right. Yeah, and I think it's for the people to make noise that this should be the law, and the legislators should then make that law. And the judges can't be asked to make the law. And if marital rape is not a crime, then the judges can't obviously use it. But I think there is enough flexibility in law that a good judge, if he or she finds that there is a marital rape, but there is no offense like that, then they can use other offenses, for instance, assault and battery, and go harsh on the criminal. But yeah, you're right. Well, so what you're saying is that, so isn't it true then, Soham, that the legislators are not acting to do the right things in a efficient, quick manner?
Yes.
Yes, it is, of course, because legislators once upon a time were lawyers.
Right,
Be it Mahatma Gandhi, be it Sardar Vallabhbhai Patel, lawyers were the office bearers for quite a long time. I would say rather lawyers made the independence worthwhile while drafting the
right,
constitution, even afterwards, while making it more applicable, more relatable to the public at large. I think lawyers were always there to legislate, but
right,
for a few cycles of the new governments, we are seeing that more and more power liking people are holding chairs, but
right,
on the other hand, they don't know how to legislate. They also do not have that touch with the public at large. I mean, I can say that my constituency has one MP and three MLAs, but they never contact like the earlier era where kings were, they will disguise as a common man and go in the streets and ask what
right,
troubles they are actually facing. I
right,
wouldn't expect that to happen, but all they are doing is unke man ki baat rather than listening to public ke man ki baat. So
right,
they actually created a gap between what is expected by the citizens of India versus what they want to bring as a paradigm shift by
right.
introducing new laws.
They should have enough experience, even like you were saying earlier, there used to be legislators. Now, a lot of them are alleged criminals. So they should
Yes.
have enough experience with law.
Correct.
Yes.
So, CJ, back to, since you do so much criminal work, in a lot of countries, developed countries of the world, 80, 90, 95% of criminal matters are handled and resolved through plea bargaining, where the prosecutor and the defense counsel and the judge blesses, but the prosecutor and the defense counsel agree on a deal, maybe a lower crime and a lesser sentence, but the matter is resolved quickly. And
Quickly.
and we all know that criminal defendants, people that are charged with alleged crimes, those matters should be handled in an expedient manner because lives are at stake. Maybe the breadwinner of the family is the alleged criminal. But I'm told that not even 1% of the criminal matters in India are settled and resolved on plea bargaining. So if you're law minister, what would you do?
For plea bargaining, to effectively contribute in the disposal of criminal matters in India, you should be having some kind of civic sense. You know, I'm sorry to use that, but that kind of self-realization, reflection of mea culpa is not there in amongst our people. So plea bargaining is not going to be effective because most criminal cases where big people are involved, in such cases, if somebody dreams of plea bargaining, that man may not see the sun next day. Such risks are there. As a law minister, if given a day, I would implement instead the video live recording of all the court proceedings except instead of only a few courts relaying the proceeding, like Supreme Court of India has a live relay of important cases, constitutional cases. But if all the courts are made accountable by video recording of the court proceedings and live relay of all the court proceedings, the system will become transparent and there will not be any room for any arbitrary delaying of matters. The dilatory tactics employed by lawyers and litigants and the other stakeholders will completely come down. If I, as a law minister, issue the dictate, to issue such a dictate, it does not take more than 5 minutes. Once it is issued, then it should be implemented within 24 hours in all the courts in the nation. And that will definitely bring down all the menaces which we are now facing in the criminal and other litigations.
Why doesn't plea bargaining happen in India? I'm told that there's 20, of the 49 million pending cases, 25% of them, about 13 million cases, are criminal matters. Why don't the judges encourage, and why doesn't the system encourage and people encourage that the prosecutor and defense counsel should arrive at a deal and not do a trial and let the judge bless the deal and let the defendant start serving the time? Most of the people in prison would have been out by now had they just pled guilty on day one.
That is correct, but there is, people do not have that much faith in the system. That faith has gone. It has to be recovered by positive action. There is on a daily basis, there is a difference of opinion between the executive and the judiciary, and it takes a dirty color many a times. There is a law made for the implementation of NJSC. Then that thing is set aside, and such things are such fights take place in the open arena, and so many controversies are reported, and we read it, which has taken the faith of the people away from the system. Only once the faith is recovered, then can we think of suggesting measures like plea bargaining, etc. Today, the harsh reality is that very few in the judiciary also believe in this plea bargaining, and even the defense lawyers, most defense lawyers, even I will not advise my client to go for plea bargaining because I cannot predict what will be the next step. I do not know what will be the corollary if I advise my client to go for plea bargaining.
Well, if you make a deal with the prosecutor and get the charge reduced and the sentence reduced without a trial, and then you have the judge approve it, then you don't have to worry about what's going to happen. You know what's happening.
I'm yet to see such a prosecutor.
Have you ever tried talking to prosecutors saying, hey, instead of 35,000 rupee crime, can you reduce it to 5,000 and do 3 months instead of 2 years, and let's move
See,
on?
that kind of things we do here. There are certain offenses classified as petty offenses. Certain
Yeah.
offenses are classified as compoundable offenses under Section 320 of CRPC. Offenses falling in these categories, they are almost always dealt in this very manner, where the accused pleads guilty and the magistrate gives him the least sentence. But there have been occasions where magistrates have, instead of giving a least sentence, have given the maximum sentence, thereby totally discouraging such plea bargaining. We call it pleading guilty instead of plea
Okay.
bargaining. Yeah, that
I
out
see.
of to 1 out of 100 magistrate, if he says, okay, you plead guilty, then I sentence you to the maximum. I have seen such a thing happening in front of my eyes.
Okay. All right. So, Sujata, you're saying that the public has lost faith in the judicial system. And do you know why and what can we do about it? Okay. We'll wait for Sujata to join us. So, Sonal, are you willing to talk? Tell us what should be included in the letter to the law minister. What do you want fixed?
Hello everyone. Hello. Are you able to
Hello, Sonal. We can hear you.
I have no views about it. I don't think so.
But you wrote on the chat that the public doesn't have faith in the legal system. Do you know why?
No, I haven't written anything.
Oh, okay. Sujata wrote that. Yeah. So are you happy with the legal system, Sonal?
No, I'm not happy with this system.
What are you not happy with?
It's a complete infrastructure is not according to public need.
Okay.
That's why we have to improve in every corner and every field which supports judicial system and with how to deliver justice to the public. और इसमें सबसे बड़ी प्रॉब्लम ये है कि जो हमारा इंफ्रास्ट्रक्चर है उसका हर एक जिसको कहते हैं, अगर कोई मशीन की हम बात करें तो उस मशीन का जैसे हर पुर्जा खराब है, उस तरह से हमारे पूरे जुडिशियल सिस्टम का एक एक पुर्जा खराब है और हर जगह रिफॉर्मेशन की जरूरत है. अगर हम कानून की बात करें तो वहां रिफॉर्मेशन चाहिए. अगर हम सिस्टम की बात करें तो उसमें अगर जो पुलिस सिस्टम है उसमें पुलिस रिफॉर्म्स चाहिए. इन्वेस्टिगेशन प्रॉपर किस तरह से हो, मेडिकल सपोर्ट्स जहां से चाहिए, जो जिसको मेडिकल जूरिस्प्रूडेंस कहते हैं, या एविडेंस, हाउ टू कलेक्ट एविडेंस वाली बात जहां पे है वो किस तरह से होगा, फोरेंसिक्स किस तरह से सपोर्ट करेंगी. हमारे यहाँ पे किसी भी तरह का एक प्रॉपर चैनल नहीं है कि हम जस्टिस को प्रॉपर डिलीवर कर पाए. क्रिमिनल मैटर्स उसी तरह से इफेक्ट हो रहे हैं, सिविल मैटर्स में उसी तरह, जिस तरह से पेंडेंसी चल रही है. और जो हाल अभी तक अगर जुडिशरी की बात करें तो अनस्किल्ड जुडिशरी जिस तरह से आ रही है वो मोस्टली इस बात पर डिपेंड अभी इस वक्त क्या कहते हैं ध्यान दे रही है कि उनको किस तरह से उनका कोटा पूरा करना है. वो सिर्फ उनकी नौकरी को बचा रहे हैं बस कि किसी तरह से हम नौकरी कर रहे हैं, वो नौकरी हमारी चलती रहे, लेकिन जो पब्लिक को जो चाहिए वो किसी भी तरह से नहीं दे पा रहे. अगर किसी एक्ट में लिखा हुआ है 60 डेज में इसमें रिलीफ होना चाहिए तो वो 60 डेज 60 डेट्स तक पहुंच जाते हैं वो 60 डेज तक भी अगर मिल जाए, अगर हम जैसे डोमेस्टिक वायलेंस एक्ट में ही लिखा हुआ है कि 60 डेज में वो डिसाइड होना चाहिए, तो 60 डेज तक तो उसमें एंट्री में डिसाइड नहीं होता। इसी तरह से मेंटेनेंस का है, और भी अदर लॉज हैं, सब में इसी तरह से। तो हम उस व्यक्ति को उस तरह का रिलीफ नहीं दे रहे जिसके लिए वो व्यक्ति आ रहा है, तो ये सिस्टम सपोर्ट तो नहीं करता, तो इसको रिफॉर्मेशन तो चाहिए।
Thank you, Sonal. Who else do we have? Avish?
I would like to add something to what she said.
Yes.
Recently, there was a talk that the Indian Penal Code is very old, which is resulting in very less conviction rate. Actually, the problem is not with the Penal Code. We require a special act called Public Servants Accountability Act, in which the investigators, the police investigators, as well as the public prosecutors are to be held accountable. The law as of today, the CRPC gives several duties to the investigating officers, the police, the magistrate, and everybody. And the law is silent if there is a dereliction on such duty. Today, what you see in most criminal courts is that the public prosecutor, barring a few exceptions, are fully corrupt. For giving
Yes.
say on bail application, they expect some kind of money, some appeasement. When we tender a bail application, the public prosecutor has to give his response. Unless you give some money to him, he will not respond. And if you complain to the judge about the same, the judge says it's between you and him. This is what I have noticed in many of the lower courts in India, in Mumbai, including the Sessions Court. Therefore, I completely stopped practicing there. I'm fully concentrating in the High Court. So whenever I get a client who calls me to the lower courts, I don't go there. I don't like, because that's the tendency there. There is absolutely no accountability. Every public prosecutor or police inspector, investigator has got a what you call godfather in the ministry as an MLA or minister or MP, and they go scot-free. There is absolutely no accountability. If we bring an act in the shape of a Public Servants Accountability Act with good punishment, including confiscation of salary, seizing of salary, and bank balance, etc., it will go. It will be very effective in implementing, in restoring the system. Our system is very good, but it's in very bad hands. That is the problem.
Right. Advocate Nirmal Preet Singh, what would you like to that we should write in the letter to the law minister? What do you think is wrong that needs to be fixed? Hiraji, are you there?
Good evening, sir. Avish this side. If there is nobody available to
Yeah.
speak, then if may I. First of all,
Please.
very good evening. And just like 10 minutes ago, I saw this email popped up on my inbox, and it's like it touches my heart and soul. So to just mention in the backdrop, 7-8 years back, I was offered a job in a US law firm in Miami, Florida. I didn't choose it because I thought much more avenues and changes we could bring in India. And yes, but unfortunately, the road has been quite tough so far. So for the past now 4-5 years, I've been practicing. Apart from the corporate transactional practice our firm does for national international clients, so I have my decent experience with the courts here, especially in Jammu and Kashmir. So I don't know whether, of course, the circumstances are a little special here, but as what I'm hearing, it seems to consonate how it is happening in other states. So the problems, they're multifold problems we have in judiciary here, or the justice system here. Like what I heard, of course, CRPC, IPC, colonial laws, which require changes, and it has not been done. Government trying to control judiciary with tribunalization. We had a lengthy discussion, even there's some judges were there. So this tribunalization is actually killing the justice system, because the ex officers of the government or retired judges and all, and so much of influence and vested interest come into the play. uh, I have failed to understand the courts, the clerks, the judges. The salaries are drawn from public funds, isn't it, from our taxes and all? But the outlook is to support, to defend the government. It seems like the honorable judge is nothing more than an advocate of the government. Either they'll pick up some issues in the procedural law, which even are not there, or of course they are in a position where they could dictate things and the course of the case. But even I had heated arguments so many times. For example, the cat matter, service matter. So the judge took out some pretty procedural issues, but I said that the cat, it is there in the Supreme Court orders and everything. The cat is ruled with the natural rules of justice. So again, Supreme Court has so many times agreed that whatever precedents they take out, they are not followed by lower courts. So that is one major issue. They are not followed by lower courts. Then, of course, there is another issue is the quality of legal representation a litigant could receive. Then again, the expectations, people don't understand how defunct the system is, which even some retired CGI has said that the system is defunct. So issues are multifold, and actually we will need to. It's just like 10 minutes back, I hopped onto this email and saw this amazing thing happening right now. I'll definitely brainstorm and come down to the points which we must serve to the honorable law minister as suggestions for improvements in the system.
So Avish,
yes,
if you had a magic wand and could change one thing in the Indian legal system, what would that be?
I would say that the judges should be elected from the lawyers through voting system by the public. Let's do it. That
Okay.
would be a magic wand, trust me. You know,
Okay.
the selection of the judges has to be through lawyers, through a public system voted by the public, and that public should also be, like you say, accredited investors in US. The public should be intellectual voting public with a minimum qualification, something we could put on. That is
Okay.
I think that would really work. That would really work.
Okay. Wonderful.
Uh,
Yeah, Hiraji, go ahead.
Yeah, good evening. Good evening, everyone. Yeah, the first thing which, if I be a law minister, I should add there should be a criteria for hold on. There should be a criteria for practice before appointing as a magistrate, because what we are getting these days that just after the law school, when they join as a magistrate, they misbehave. They just rely on the theoretical knowledge. They don't have any practical knowledge, which is affecting the system these days. So this is what I want to add.
Okay.
Secondly,
Otherwise,
secondly, there should be a gender neutral rape laws.
okay.
Rape laws should be changed, because nowadays it is not like rape can only be done on a female. It's like there is a male on male rape, there is a female on male rape, so there should be law for that also.
Right. Yeah, I guess all they need to do is change a word or two, and it solves everything.
Thirdly, what I want to add is that I want to enhance the public defender system, which was recently adopted by National Legal Service Authority. I want to enhance that system. It's a good system which is already running at a good as other countries.
Okay.
Yeah, these are the 3 points which I want to end.
Okay. Thank you.
Yeah,
I think the overall revamp is needed.
exactly.
But we're looking for points to write to the law minister specifically, and we're trying to avoid saying to the law minister that fix everything. Everything is
Yeah,
wrong. Fix it.
no, that's impossible. That will not be taken
Right.
at all seriously.
And the law ministers may be removed from reality, may be removed from what's happening on ground, the problems all of us
Yes.
face in courts and the delays. And the law ministers, I don't know how much they know and how much they don't. For the
I
last
remember
6 years, we had the law minister as the IT minister also. So fortunately, we have a person now who's just a law minister. Or maybe they listen to us.
one more thing is I find, okay, it's like, we are we are working at the ground level and the policy makers have no idea what's happening there. They
Right.
just have no idea. I mean, in fact, we used to, when I was a student, we used to say, I mean, they would discuss what is happening in a 5-star hotel where there is, nothing related to what reality really is. So you end up making a lot of policies and end up making a lot of laws which actually do not make sense at times. And why have laws which are so ancient and primitive? Things are changing rapidly. Why can't system also be, at pace with them?
Right. So that's why we thought we'd hold this session, because we're the industry body. It's our duty to tell the government that on ground, this is what's happening. These are the troubles we're facing, and can you please look into them and fix them? But we want to give specific points. I think I don't even know if the law minister believes that we have a system that is not super efficient, and maybe they're just happy with it. I heard one minister talk about 3 months ago, and Minister Goyal, and he said we have a robust, wonderful legal system in India.
Wow.
And I'm
Wow.
like, okay, great. Where do you start, right? Where do you start with a person like that? I said, okay, fine. I'll just have my cup of tea and move on in life.
But that's so true. They're in their own illusionary world.
Right. Yeah. It's a beautiful marketing agency, advertising and whatever. Yeah. They've brainwashed themselves that we have a robust, wonderful legal system.
Perfect system. Yes.
So just I want to interpret here. Another burning issue is regarding adjournment of cases, and especially where the lawyers are responsible for that. And on a particular day when the case has been fixed, suddenly the junior will come and give some process. Today, my senior is not available. He is traveling, and there should be some limit on adjournments, at least maximum 3 times, not more than that, unless there is a serious medical emergency. So this
I think there's no accountability. I think that's the major issue.
Yes, exactly.
Right.
If I may please, a short input on adjournments. So what the system is, if the private litigant does adjourn the case 2 times, 3 times, the judge may probably dismisses for lack of prosecution. But the government counsel is given leverage to adjourn it for 3 years, 5 years. This is especially the practice prevalent in high courts. Extensive. They are privileged to adjourn it for 10 hearings, 12 hearings, nothing. If private side, we do it for 3, 4, the judge may dismiss, and they have started to dismiss. This point. So it's the adjournments. Yeah, there has to be a cap, which has to be uniformly applicable on both sides. Another one point we need to include, I suggest to include in the letter is the percent of budget we allocate to judiciary. If you will do some research, it's around 1% of the state budget, which is way, way, way less. I say after defense, the department in India which requires the budget after defense has to be judiciary. So the defense allocated to judiciary needs to be increased. If they do not have the money, let's come up with an innovative structure whereby you charge litigants, not a problem. Somebody is filing a family law case, you charge 1,000 rupee fees. High Court, you charge 2,000 rupee fee, not a problem. Litigants are paying advocates around 50,000, 60, or whatever it is the amount is. But make it efficient.
Right.
Charge, make it efficient. Let's come up with the semi arbitration module. You know, let's be innovative, creative here. If you do not have the funds, they do. That is not the problem. They do, and probably something like that.
Right.
And one more thing, in high courts and all, again, leverage. What will happen? The courts are constrained with the time. They have hardly 2 hours in one sitting, and then the lunch break, and again 1.5. A lot of times, some prominent senior lawyers would be given 1.5 hour, 2 hours to speak, and on a point, the judge is also not listening. He's just there. Okay, fine. You are a senior counsel. I have to hear you. And at the same time, if a junior would come up with a much more pivotal issue, he, on the other hand, would be given 10 minutes, 5 minutes, or something like that. There may be, I don't know, this is again a tricky subject on which we could have debate on length, but there has to be a cap on the minutes for pleading your case in honorable courts, especially in high court, maybe 45 minutes or 30 minutes, or after 30 minutes, by the permission of the honorable judge, 15 more minutes are allocated. Something like that, maybe.
Correct.
Right. What do you make of, Swapnil will get to you in a minute. What do you guys make of this senior counsel animal that we've created in India? I thought the constitution is everybody's equal, and
Yes.
look at what the government is doing, arguably, that the government itself is now calling somebody a senior advocate. Maybe a junior advocate is way smarter than a senior advocate. And why can't we let the system work out and let the good people get ahead in life? The government, whose job it is to make sure that it's a level playing field and nobody is discriminated or no class system created, the government itself is branding someone as senior counsel. How is that constitutional?
It is not.
Absolutely.
It's definitely not.
See, as per the High Court rules, if you go, they have specific rules which designate, which define the term senior counsel, which says if you have a practice of 15 years and then so and so cases, and advocate of good moral structure and all, and then you are given, and then you have to file a application, and then you are given that designation. This is the rules which govern it. I'm not against it. If somebody has devoted so much time to law and they are pioneer in law, fair enough. They deserve that designation. Fair enough. We're not
Why?
against it.
But in what other field does that happen? Does that happen with members of parliament? Does that happen with doctors? Does that happen with plumbers?
Doctor, experienced doctor, that is well, maybe probably there would be some fields if we brainstorm, or if I recollect, like you have a vice captain, for example, in sports. But again, that's a different thing for sure. Vice captain doesn't.
Right. There's no issue with vice
Yeah.
captains and seniority, but the government shouldn't be in the business of discriminating.
Yes. Yes, agreed. It has to be totally out of the government purview. That I
Mr. Chok, there is something more to it. May I talk on this?
Yes.
The origin of designating an advocate as senior advocate was something else. Now it's something else. Actually, the advocate who is designated as senior advocate, he has got certain restrictions. The first restriction is he cannot charge fees from any client. Second restriction is he cannot be briefed by any litigant. He has to be briefed by another advocate.
What happened to a free country?
No, I'm coming to it. Why the senior advocate was designated was to enable the courts to seek opinion in important matters from an advocate whom the court trusts for his knowledge and standing.
Haji,
So
bolo.
basically, he was for the consumption of the court.
Hello.
So if there is any senior advocate in the
Hello.
court, and
Haji, Haji. Bolo, bolo.
this is one of the reasons why there is a lot of problem in our country. There's disturbance. Can I continue?
Yeah, so
Go ahead.
but the question, CJ, is what are we writing in the letter to the law minister?
In
Are
the
we
letter to the
saying
law
that-
minister, we should say that the senior advocate, the institution of senior advocacy today is more exploitative. Earlier, when it was for the courts to rely on the seniority and seek opinions, unbiased opinions. A senior advocate, once he takes a stand, he's not supposed to change his stand with subsequent
Okay.
clients. But such things are happening now.
Swapnil, what do you have to say? What would you like to see in a letter to the law minister? What do you
Sir,
want?
thank you for giving me opportunity to speak out, sir. Sir, I would like to add only one thing, that the protection should be given to the lower court and district court level also, because I saw one article on the newspaper and Facebook that lower courts and district courts not getting proper protection to give the decision. So without protection, they are afraiding with the parties, and not proper quickly justice not coming into the picture. So that would be the major issue, and that should be the clear by our politicians and our law ministers, sir.
What do you mean by protection?
Because sir, openly we see in the courts lots of conflict suddenly happen between the parties, and they comes in the pressurized judges. So proper justice and full justice not comes from the side of the judges. So that is the main issues are coming, sir.
Sunita, do you understand what he's saying? Because I don't.
I think basically he's trying to say is about talking about the pressures that come from various quarters.
Yes.
Okay, I see. So influence.
Yes, influence, pressure.
Mhm.
That's what he is.
That is
Okay. All right.
Factors
I have-
affecting the independence of the judiciary.
Okay.
Factors affecting the independence of the judiciary.
Okay.
yes. If I may please for a quick minute.
Yes.
Because this is something very special and I don't want it to go away. And I totally understand with your wisdom, Mr. Chuk sir, that this letter has to focus on probably 5 points or 4 points, which we curtail down, which are practical for the ministry to implement, rather something which goes vague and 51 points and they say, okay, keep it in abeyance. One very good point is, which even Supreme Court has agreed that the judges do not follow the precedent set. So maybe an online portal system where a lawyer could upload the judgment. Of course, that is, we could say you have to raise it. You could file an appeal on it. So maybe a grievance system which works out well.
Okay.
I'm not sure how we will implement it. I'm sorry. Maybe probably need to brainstorm more on it. I'll
Sure.
get back.
Yeah, please think about it and send us an email. That would be
We
great.
will. I'll come with the proper points. No worries.
Yeah.
Yes, I think yeah.
So Devapriya and Chadaram, you two haven't spoken. If you have something to say, please tell us.
Hello, sir. I am
Yes.
Devapriya. Thank you for letting me speak. And the only thing I would like to suggest is, if we can, I don't know how to implement this, but if we can introduce more expertise to the judges. For example, in the laws regarding to IPR, IBC, and such specific civil laws where most of the judges are not much proficient. Due to this, when the cases go to appeal or just go to those judges who are not much proficient in it and yet are giving judgments to it, the judgments that are given are not satisfactory. Thus, again going for, reappeal to the higher courts. This just prolongs the whole process and just increases the number of cases. So if anyone asks me, I would suggest that more such expertise should be brought to the judges, specifically those who are interested. Like I said, IBC and IPR. This is mostly dealing with civil laws, but I think this can help decrease the number of cases by a huge amount.
Okay, so training of judges. Okay. We need to have better training. Okay, wonderful.
Yes.
Yes, Abhish.
I don't know if it happens in other jurisdictions, sir, but you would be the best person to comment on it. Or actually, from the point which the young lawyer raised, expert matter judges. We have currently the system, the judge is taking civil cases and then the criminal cases, then the NDPS cases, and sometimes the other charges, POXO. I mean, yeah, and especially with the number of piles we have, the piles of files, actually, so many cases in a day to handle, 200, 300. You can't imagine a human being jumping from one law to another law, and when the law is so vast. And as you understand, in US and all, you have one lawyer who's particularly into family law, and then that probably only into contested divorce. So this has to be looked into. I mean, yes, this is something. Expertized judges on expertise matters, something like that. They have for family courts now. Again, in the family courts also, for family courts they have come up with this. So maybe they need it for probably criminal, civil, separate, for NDPS, POXO. And like she said about IP and all, IP now the issue is in New Delhi, I believe they have come up with a code for the IP code, specifically for IP. They have come up with the code. Not in other states, of course, because not that number of IP cases which demand a special code, considering we have another so many pain points to consider. So yes.
Implementing this will be an antithesis to the dictum that ignorance of law is not an excuse. All the judges are supposed to know all the law. And it is the duty of the lawyer to educate the judge. This is what I tell my students also. A judge is not supposed to know all the laws. He has to deal with whatever law comes to him. It is the duty of the advocates of both the sides, the plaintiff advocate and the defendant's advocate, to point out the correct position of law. And the judge has to deal with it. He has to research into the judgments and then decide. This is how it works. And if you go for seeking an expert, you will not get any. Because a lawyer who has got an expertise in a particular field, he may not opt to become a judge because it's more lucrative to practice as an expert advocate than to become a judge.
Wonderful.
I agree.
Okay. We allocated 1 hour to this session, and we would like for all of you to have a good night's sleep. So if you have any more comments, please send us an email. And if you talk to other lawyers, your friends, your colleagues, ask them this question that, hey, ILA is writing a memo to the law minister of all the grievances and complaints and suggestions and solutions we have, then please ask your friends, and whatever they say, please share with us. We'd like for this to be a comprehensive memo. And we want to release it to the media as well, because when we ask Times of India that, hey, we opened a new ILA chapter in a city, can you write about it? And they say to us, do something. Then opening a chapter and we will write about ILA. What's the heading? And so what suggestions do you have? And so we will share this letter that we write to the law minister with the media as well.
Good. Pleasure, sir. It's a revolutionary bringing start from you, and it will go very far. It will go very far.
Thank you so much, everyone. Thank you. Please keep supporting ILA. And if you have friends in other cities where there's no chapter, please give us the names of your friends so we can approach them and have them start a chapter in their cities. Thank you so much, everyone.
Thank you.
Thank you so much.
Everyone.
Thank you.
Thank you, everybody. Thank you.